There are really two types of appeals in the criminal courts. One appeal will tend to occur where fresh evidence has been discovered that was not available at the time of the trial, that is material and relevant, and tends to suggest that there's been a miscarriage of justice. The second sort of appeal is where something's gone wrong in the trial process. Either evidence has been admitted that shouldn't have been, or excluded when it ought not to have been, or the judge has made some error in the course of his summing up that's resulted in an unfair verdict. Since I've been appointed Queen's Counsel, I've probably appeared in at least 150 cases in the Court of Appeal Criminal Division, dealing with all types of criminal appeals. Some of those have been very high profile, others have been more mundane. Two examples, perhaps, to illustrate the position would be the appeal of Barry George that I conducted. He had been convicted of the murder of Jill Dando, the television presenter. His case was referred back to the Court of Appeal by the Criminal Cases Review Commission. We were able to call fresh evidence during the course of that appeal, and his conviction was quashed. He was then acquitted in his retrial that I conducted at the Old Bailey. Another example was that of Mark Dallagher, who was the subject of a BBC Rough Justice programme. He'd been convicted of murder based largely on an earprint that had been taken from a window pane of the home of the deceased. Again, the case was referred to the Court of Appeal by the Criminal Cases Review Commission, and again we were able to call fresh evidence and the conviction was quashed. In that case, ultimately, the prosecution offered no evidence against him. Well, of course, it's the high-profile cases that always grab the headlines, but they're only a small minority of the cases that you actually conduct, and the vast majority of my cases in the Court of Appeal have been for perfectly straightforward cases where something has gone wrong at trial. Either there's been a miscarriage of justice and fresh evidence has been found that indicates that the person convicted has been wrongly convicted, or something has gone wrong in the trial process. Either evidence has been excluded that shouldn't have been, or admitted but it ought not to have been, or the judge has made some error in his summing up. So anybody who feels that they've been wrongly convicted should not hesitate but to seek advice as to whether or not they've got arguable grounds to appeal that conviction.